So yes, good evening members. Today we'll be doing orals preparations, and I'll be basically extracting my questions from the orals made familiar that is making rounds in social media for the 2018 to 2022 time frame. So I'll be able to reshare the same after we are done with this session, because I don't want a situation where somebody's looking at the answers. So, Madam Abigail, I'll go first in cross-examining you. What are the exceptions to the rule against hearsay? You can give as many exceptions as you want, because provided I'm asking a question, I must clarify and give the answers. And peer on your end, if you ask me a question, you must be in a position to know the answer or an idea to the answer. So that's how we can conduct this session in a practical way. So, Madam Abigail, what are the exceptions to the rule against hearsay?
Thank you for that question. Hearsay is provided for under, I believe, Section 33 of the Evidence Act, where it gives for the exception, and it includes number one, on the documentary evidence. For example, a written statement is made during civil proceedings. It will be admissible if the maker or the one who wrote that statement had personal knowledge of the facts, or if it was recorded in the ordinary course of duty by that person who received information from a person with that personal knowledge. I really hope it's clear. So number one is on that angle on documentary evidence. And then number two, just on the documentary evidence or public documents. On the public documents, it is an exception because any entry that is made in a public, say, registry, and it is made by a public officer in the discharge of their official duties, then it should be admissible as hearsay, because there's that presumption that everyone knows it, so it will be admissible to prove the I believe the facts that are in that registry, public registry. And then the other hearsay rule, the exception, is where I believe where a maker of the statement had passed on, so the statement can be it can be also referred to, it can also be inadmissible. And I'm thinking in cases of in this case where the maker is unavailable, so it could be cases where the maker died or is incapable of even testifying before the court. So the law normally allows for such statements, which are called the dying declarations, to be made, and they shall be admissible. And then the other exception to hearsay is okay, I don't remember, but I think I remember something to do with res gestae, but I'm not really sure about it, and I don't know how to explain on it. Yeah, those are the exceptions.
Thank you so much, Abigail. I'm very satisfied with the answers. And maybe for clarification purposes, registry are the reported words that are so closely connected as to form part of the transaction. So you have correctly captured that. We have exception to the rule against hearsay when it comes to where the witness or business documents relied on are unavailable. Public information, you have correctly captured the same. You have also talked about expert evidence. You have also talked about statements of witnesses who do not testify due to fear. These are just additional points. Confessions are also exceptions to the rule against hearsay. Now, the tables can turn where you can also ask me a question. I see Mr. Martin is also in. So, Mr. Martin, welcome. We are using an open forum where any member can ask any other member a question, and provided you have the answer to the question that you are asking. Yes, thanks.
All right. Okay. Martin can go.
Sorry. I was saying thank you.
Okay, welcome, Martin. My question directed to Vicky is on the explain to us the doctrine of indoor management as well as constructive notice.
Thank you, Madam Abigail, for that question. And the doctrine of indoor management is a doctrine that explains that if there is an internal arrangement inside a company, and then the external party relies on a certain procedure or authentication that arises from any member of that company, it is not the responsibility of the third party to know the internal operations of your company. So those actions will bind that company. You have also asked about, come again to the second question.
The second question, okay, it was just a tie or that, so it was on constructive notice.
Okay, thank you. So if the company does not want various members to bind the company, it should issue out a constructive notice to notify the third party, hey, look, these are the authorized individuals to act on our behalf. I stand guided, Madam Abigail.
On the constructive notice, it is a document, or not really a document, but a doctrine that presumes that the outsiders or third parties, they know everything about the company, including the public documents such as the memorandum of association and articles of association. So the importance of this constructive notice is it prevents it prevents it protects third parties. It prevents the company from penalizing. Okay, let me just start again. Sorry. Let me just start from the indoor management rule. My understanding, and it is also called Tanquad rule. And the indoor management rule, the purpose of that rule is to protect outsiders by shielding them from any irregularities or irregularities that happen inside the company. So, in other words, for example, if you are a third party to Safaricom, the indoor management rule is going to help you because you are working with the presumption that every rule that is in Safaricom is being followed, and so long as you as the third party, you also work according to what you expected. And the constructive notice now, in this case of Safaricom, is that any sort of document, any sort of document that is made public by the Safaricom, then the constructive notice presumes that you as the third party, you will be able to find the document. So in any case that you raise there's something wrong about that document that was published by Safaricom, then the presumption is that you cannot come again and blame the company because that document, that's presumption under the constructive notice, it presumes that you read and you understood and you also agreed to it. Yeah, I think that is my understanding on it.
Mm-hmm. Thank you so much, Madam Abigail. Mr. Martin, do you have a question to pose before us, or we pose a question to you so that we join you in the circle?
I want to do a rejoinder on management fundamentality and the constructive notice. And my rejoinder will be on two perspectives. Number one, when you are dealing with companies, the company is supposed to be a separate juristic person that can sue and can be sued. And so whenever you have internal policies for a company, then a third party is expected that those internal policies are going to be followed, so that anytime they are dealing with a company, then it is assumed that the company has followed the internal processes, so that party is not expected to know what Abigail has said. It protects the third parties against liabilities that are likely to arise from decisions that have been made when they get engaged. And it actually falls, it was explained in the TACAD rule, Israel case of 1893, I think I'm not sure, 1983, sorry, and it actually says that you're not supposed to, the company is dealing with that party, the other party is not obliged to know the internal processes, the policies, to that extent. So you cannot be able to hold them liable. So that if, for example, the company gets into a contract with the other party gets into a contract with the company, then you cannot be able to come and say that you are stopped, the company is stopped from those obligations that falling due to the so the same case with contract notice that you're supposed to take notice of what is the public domain. Like, for example, when a newspaper has been put out about an executive director who was left the company, then it's public notice that that person is not going to present that company was dealing. So it is supposed to be what is public in the public domain. So I think for Abigail, there's the only one correction I want to be able to make. The articles of association, you're not likely to be able to know what exactly is contained in the articles of association of a company. Remember, this is the constitution of for the company. So there are those things that are not likely to come to the public fora. So, but things which are in the public fora, like, for example, you need to take constructive notice. For example, the CEO has been fired and they have put a newspaper in national media, then you're supposed to take notice of that. If, for example, the company has been put under liquidation, then you need to be able to take notice of that. Because, these are things that are in the public, and that is what the constructive doctrine is all about. So I thought I needed to be able to just be able to bring that into that perspective. Thank you.
Thank you so much, Mr. Martin, but your voice is so low. I don't know why your device is having such a low noise. And also, maybe to do a further rejoinder to that is the fact that you can also be told to distinguish between an actual notice and a constructive notice. In an actual notice, you'll say that the person genuinely knew the fact, while on constructive notice, the person did not know but should have known through reasonable diligence. And Madam Abigail and Mr. Martin, you have correctly brought it down the way it is required. So this question will go to Madam Abigail, then you will ask your question. So Mr. Martin, have you clarified that you want us to join you in our circle, or you want to be tied to rejoin us?
I want to be joined in the circle.
I think now this question goes to you, Mr. Martin.
Yes, please.
Why is the case of Karisa Chengo decision an important decision or a landmark decision in Kenya?
Karisa Chengo decision, and correct me if I'm wrong, it is on the third wife, the three wives. Is it so? Kindly correct me.
No. It is emanating the question from a jurisdiction, and it comes even to criminal matters specifically. Yeah. So you can try again. Or Abigail can save the situation if you want assistance.
What you're saying? It is touching on jurisdiction and of criminal matters.
Yes, it has a certain element of jurisdiction.
Okay.
And criminal, Kombali, yani it is a landmark for various reasons, but I know the decision that you are confusing with.
Okay,
You're
fine.
confusing with Akina Desmond.
Let Abigail give it a go. Give it a bite. Abigail.
Okay. The decision or in the decision made from that case on Republic versus Karisa Chengo, it highlighted a lot of things. Number one, on the issue of if ELC courts, judges, that is judges of specialized courts, can hear and determine matters of criminal. So in this case, I believe it was Justice. I'm not really sure if it was Maraga or Mutunga. He had he had impaneled Justice Angote and some other justice of the ELC to hear matters on criminal matters, because it was I think that was the moment where they were having these judicial weeks to handle a specific type of cases. So I believe it was Karisa Chengo, because he I think he was detained or something as a result of that. So he came and questioned on the if these judges had that power to listen to criminal matters, and the court stated that the appeal to the Supreme Court on that case was that specialized judges of specialized courts cannot, in any sort of way, listen to criminal matters, because we know from ISO cases, what is this case? Those for jurisdiction, I don't remember the name, but jurisdiction must be derogated from the constitution or a specific statute. So if it is not expressly written, then then you cannot arrogate yourself jurisdiction. And then number two, it also talked about the right to legal representation. It said that we know this rule emanates from Article 50 on right to fair trial, and every accused person is required. Actually, they have a right to legal representation. I think I remember those two. Yeah.
Thank you so much, Madam Abigail. You are well read when it comes to that landmark decision. As per the rule of the book is that we must clarify our questions. So the decision emanates from the Supreme Court. It was decided back in 26th May 2017 by the Supreme Court of Kenya. And the main holding was that the Supreme Court held that although the High Court, the ELC Court, and the Employment and Labor Relations Court (ELRC) are courts of equal status. They are not the same court and they do not have interchangeable jurisdiction. Each court can only exercise the jurisdiction given to it by the Constitution and statute. So the key takeaway why this decision is important is that it was decided that let me go to the notes. The case is important because it clarified three things. Article 162(2) of the Constitution, courts are equal in status to the High Court but separate from it. The ELC and ELRC are specialized courts and not divisions of the High Court. And the jurisdiction is conferred only by the Constitution or legislation. And judges cannot move across the High Court, ELC, and ELRC merely because the courts are of equal status. And as per what Abigail tells us is that they were questioning whether Karisa Chengo decision had capacity to listen to criminal matters arising in regards to criminal matters arising before the ELC and ELRC courts, and the Supreme Court clarified that as to much. Then there is another aspect that Abigail has gotten correctly when it comes to the criminal. right to fair representation by a counsel, and this is to tell you that we have a test where the court will have to look at. It is not a direct interpretation that where you request for a fair a representation by a state council, you will be given. No, we must look at whether you will likely to suffer inaitwaje unfair, you will be subjected to inaitwaje principle unfair, you will suffer unfair procedural technicalities, because the substantive matter of the dispute iko complex. Yeah, it is about murder, easy capital offenses. Then those are the elements that will guide the court to request for your right to fair trial to be right to be represented to be granted by the state. So those are the elements that are arising in the Karisa Chengo decision, and that is a very good attempt there, Madam Abigail. So I'm bound by your question. Yes, Mr. Arnold? Yes, Mr. Martin, you can take the floor.
Okay, from what I understand from the case.
Sorry.
Okay, can you hear me, guys? Hey, guys.
Yes.
From what I learned from the case, it was a criminal matter. Well, that Karisa Chengo was convicted with two others, if I can do remember. It was Malindi. So 3 judgments, 2 are from High Court, and then one of the selected was from ELC. So from as in electronic capture, what I captured was that as in you have stated, status equal does not mean any judicial representation or jurisdiction, something like that. Yeah, because it was if I do remember, the Supreme Court declared that ILC judge cannot sit down with the High Court judges to determine a criminal issue or a criminal proceedings. So, as in my question was, as in per this Ladback case, what were they trying to, what jurisprudence were they trying to set? Is it that, the ELC, the ELRC, and the High Court, they have same level, but no way a specialized judge from High Court can go to ELC or ELC to determine the matters of employment or environmental land issues. Ama, did I get it wrong?
No, umeishika vibaya. Karisa Chengo, key takeaway ukiweza ulizwa before going to many things, anataka kujua kama umeshika. Karisa Chengo stands for the proposition that criminal appeals from subordinate courts must be heard by judges of the High Court and not judges appointed to specialized superior courts, namely the ELC or the ELRC. Wewe umesema about superior judge on the High Court. Hapo sasa ndio ina conflict.
My question is, in this case, was it appeal from magistrate court?
Yes, it was an appeal from the magistrate court na ikakuwa appealed all the way to the High Court. Sasa the issue on jurisdiction ndio ilienda ikipanda to be determined by the Supreme Court, but now the gist of the dispute mali arise ni where this appeal is being taken to be heard. So walileta other judges of the ELC na ELRC kwenye ulikuwa umecapture.
Okay. So, but from that issue, if I do remember, only one judge was from ELC, from the 3 bench judges. Only one judge was from the ELC. If I got it correct.
Madam Abigail will clarify. I see her hand. Mr. Martin Pia?
Yeah, if you go to the judgment in paragraph 51, it says that in as much as they are ELRC and ELC exercise the same powers as the High Court, the difference comes in when it comes to jurisdiction. Remember, jurisdiction for the high court, they wanakuanga na original and unlimited jurisdiction when it comes to criminal matters. However, for the ELC and ELRC, they have different jurisdiction in that because they have specialized jurisdiction. They deal with matters concerning land and matters concerning employment, respectively. So the decision now, they were trying to differentiate this the jurisdiction. Wakisema this judge, Justice Angote from the ELC, cannot hear matters on criminal because he's a specialized judge, meaning he sits in a court that has specialized jurisdiction, unlike the judges in the High Court. So there's no way in that bench the Karisa Chengo was saying there's no way that you will accord me the right to fair trial, yet the case that is being handled is handled by someone from a specialized court. So the issue that was the court was trying to determine was on the different jurisdiction. Yeah.
Okay, so meaning equal status does not mean equal jurisdiction. Okay, they're all High Court judges, senior. They're all High Court judges. So they have equal status, but different, very different jurisdictions, if I get it correct.
But your first statement is wrong. They're not from High Court. This Angote is from ELC. The other one.
Okay, when you get wrong, as in, I'm saying they have equal status. They are all nini.
Yeah.
They are all equal status as in they are in the same areas, in they are all judges.
Yeah.
No one is magistrate.
Yeah.
Okay, you go to High Court, pole. Moja no ELC, but equal status, but different jurisdiction. Okay.
We concur with you. Mr. Martin?
No, thank you for that. I need a bit of refreshment on this Karisa Chengo case. I want to be able to understand. I'm sorry to take you back on this, but just from my understanding, we are saying that this is a criminal matter that presumably that arose at the High Court, right? Where was it?
All the way from the subordinate.
So
that, there's something I want to be able to understand there. At what level then that the Chief Justice and paneled the three judges to listen to this? Because by that time we had the Court of Appeal. So did it go through? It went to the High Court, the Court of Appeal, then to the Supreme Court. So I just need to be able to understand that sequence. Kindly, if you can enlighten me, so that you don't just take me straight to the judgment. Thank you. Anybody?
Yes, I can break it down. So Karisa Chengo started from the magistrate court, where Karisa Chengo and two others had been tried and convicted in criminal proceedings before the subordinate courts. They then filed criminal appeals to the High Court against their conviction and sentences. However, the appellate bench that had the criminal appeals was not composed purely of the High Court judges. It included judges who had been appointed to the specialized superior courts established under Article 162(2) of the Constitution of Kenya, namely the ELC Court and ELRC. But it is at this point that Arnold clarifies that we had two High Court judges and one from the ELC Court. The High Court appellate bench proceeded to hear and determine the criminal appeals. The respondent challenged the legality of those appellate proceedings on the basis that ELC and ELRC judges had no jurisdiction to sit in criminal appeals, because criminal appellate jurisdiction from subordinate courts belongs only to the High Court. This matter reached to the Court of Appeal, which held that the criminal appeals had been heard by an improperly constituted bench, and the Court of Appeal found that the judges of ELC and the LRC could not exercise criminal jurisdiction of the High Court. It is at this point that the Republic now appealed to the Supreme Court, and the Supreme Court concurred with the Court of Appeal. Up to that point, I have clarified the facts. What was the main or central issue before the court? Whether judges appointed to the ELC court or ELRC court had jurisdiction to hear and determine criminal appeals reserved for the High Court. That was the issue, and the holding is direct.
Beautiful. Thank you for that. Very clear.
So it is a merry-go-round. Thank you, Mr. Martin. So, Mr. Arnold, yes.
Yeah, okay, fine. So carry on. Then I can give a go to one of you guys.
Yes, in fact, I was to give you the permission. I've asked the question. We go to Martin, we go to Arnold, then we go to Abigail in that rotation manner, so that Abigail akimaliza inarudi back to me, so that we can have a concurrence. But anyone, wakati swali imeulizwa, we can do rejoinders and additional information. So Martin, the floor is yours. Ask any person a question that you want.
Okay. Now I want to ask. Let me take it back to Arnold. Let me hear Abigail first. Now I need to know in insolvency, liquidation of companies, what are the alternatives to corporate insolvency? Hello, Abigail. Arnold wants to take it first. Did you hear my question? Can I repeat my question?
Yes, please. And is it directed to me or Arnold?
To you.
Oh, okay. Okay, let me just say what I know. The alternatives to company insolvency. I think I just know one, so Arnold will help me. And number one is on the company voluntary arrangements, which is normally a system. I believe it's a system in. It's an alternative in that it allows a company to restructure its debt by maybe proposing a way on how to pay back the company and the creditors, and normally it is I think there is normally a supervisor or in a case where maybe an already insolvency practitioner, it could be an administrator or liquidator. But I'm really thinking on the administrator who can also propose on the same. And so I think that's an alternative. I remember something, but I'm not really clear about it, but someone can help me.
Arnold.
Okay, you said
you are being asked
liquidation or what?
You are being asked to give the three methods of alternatives to insolvency now of a company, say a bankrupt individual or a natural person. They are focused on a company.
Oh, like court liquidation,
yes,
creditors liquidation, voluntarily, you remember voluntarily liquidation. So, am I correct? Am I on the right track?
Yes, those are the procedures zenye alikuwa anataka. Members voluntary liquidation,
yeah.
Creditors liquidation, then we have court liquidation.
Okay.
Which one is being used when the company is solvent? yenye ni gani inafanyika hata wakati kampuni iko na uwezo ya kulipa pesa madeni?
Sini members.
Members. What about creditors?
Creditors is when wanaona kampuni mali imeenda inaenda kusota, they come together, then maybe they find a insolvent practitioner who can take over the company and run the company as they try to pay their to pay their debts. Am I on the right track?
You're on the right track. What about to natural persons? The 3 steps for natural person?
For bankruptcy.
Yes, for bankruptcy to insolvent. Yes, to natural persons.
So to natural person, maybe yes, zinanitoka akili yangu ijamka. Okay, Mbugwa, unaweza hapo kidogo akili kuchangamka.
Before Martin I think nimeelewa swali vibaya. Was it alternatives to insolvency ama types of the insolvency procedures?
My question, sorry guys, I dropped off a little bit. I had a call that was coming through. Now, the question was, what are the alternatives to corporate insolvency? And I think you have attempted it very well. I hope because you have the voluntary liquidation that the members can be able to pursue, and then you have now the scheme, the CVA, where you come up with an arrangement of how you're going to be able to sort of just more or less like the natural person, where you do the installment order. But now for the companies, you're looking at that voluntary arrangement where you're coming up with how you're going to be able to repay the creditors. So you come up with a proposed plan of how you're going to be able to pay them, and then you're able to realize. You can be able to you get a liquidator to be able to realize, and then you can be able to pay off. But basically, I think we're going to come. Sorry, I got a call. Yes, but we can always be able to contribute to that. So Arnold, I don't know what you had said. And Victor, anybody can be able to contribute to that. But they're only
Yes. Yes, Mr. Martin, as a follow-up question, I also asked Mr. Arnold to give us the now alternatives to bankruptcy when it comes to a natural person. So he was mentioning the 3 steps, the 3 alternatives.
To a natural person?
Yes, a natural person.
Okay, for one, I can say someone can voluntarily agree I'm bankrupt. I'm out of money. Najua hiyo voluntarily, then there is court. Maybe Martin can come up.
Okay, I will attempt. For a natural person, we talk about bankruptcy, don't talk about insolvency. So a company becomes, you say it is insolvent when it's not able to meet its liabilities and obligations. But for a natural person, now you talk about a person becoming bankrupt when they're not able to meet their financial obligations, when they fall due. And for this, remember, you're guided by some regulations. We have regulation 3 of insolvency, which defines the threshold for the natural person, and it says it's supposed for you to be declared bankruptcy, then the threshold is 250,000 shillings. But also you need to be able to also look at regulation. You also need to be able to look at section 17, which defines what for you to become and to be eligible to be a bankrupt. What are the things that need to be able to come and say, fine, I'm able to fulfill. For you to be eligible to be adjudged Yeah, bankrupt. Yeah? So just for a refresher, number one, it means that you have number one, you have the debt that the debt that is being pursued can be liquidated. You are unable to be able to pay that debt. Not that you're not willing, you are unable and you don't have prospect means of paying that debt. Number two, number three, that debt has to be unsecured. Yeah? So they're unsecured, not secured. Because secured, it means that there is a car that can be sold to recover that debt. But this is for unsecured creditors. Number three, number four rather, there when a creditor has you have been given the statutory demand and you have been unable to meet, you have not been able to put in a case to be able to stop that proceeding. So basic, and of course you have met the threshold. You're within that threshold. Then also you have to be able to look at the section 19. I mean regulation 19, but you read it together with section 33 of the camp of the act. Victor, you have to confirm for me whether 33 is the Company Act or the Insolvency Act. No, it's the Insolvency Act, where you're looking at the value of the assets that you have, and here you talk about two things. Number one, you look at the total value of the debts that you are owed by the creditors, the unsecured debt. It should be not more than 500,000, and of course the debt that no, sorry, the debt should not be below 100,000, and the value of your total assets should be should not be below 500,000. All right. So the alternative now to the bankruptcy comes for the natural person in two ways. Number one, you can actually be able to go and make an application to court, so that or even to the official receiver, so that you can be able to have the instrument order, such that you come and declare and say, I have these creditors, I have these assets, and I need to be able to pay them. So I'm going to be able to pay them. And you make a proposal, a scheme of how you're going to be able to pay the debts in instrument, and that has to be done between 3 up to 5 years. So after making the application to the official receiver, then the other one, you can also go ahead and be able to make an application again for you to be declared almost like a pauper, the no asset procedure. Yeah, no asset procedure. It means that whatever assets that you have cannot even go beyond the 500k. Yeah, so hata ukichukua baiskeli uchukue nini, so you need to be, for you to be admitted to the no asset procedure, but there are certain criteria for you to be able to fit in the no asset procedure. Number one, that debt should be between 100,000 shillings. Remember the section 33 that says the small bankruptcy should be from 100,000 shillings, but up to a maximum of 4 million. Then number two, for you to be able to qualify for the no asset procedure, you must not have been entered into that register again. This is you cannot have been found in that book again. Number three, you need not also to have been a judge bankrupt before for you to be able to. And of course, you have to be able to demonstrate to court that, number one, I don't have any means. I have no means. I'm unable. So it means that in the book, in the statement of affairs, when you're making that application, it means that you have to be able to come and make a proper declaration of all the assets that you have. Yeah, so you cannot be able to go and hide some assets that you can run away from your creditors. So just like you observed in the train case where you're not supposed to go and hide. Yeah. so that you can run away from the obligation from your creditors. So so in essence, so you're supposed to make sure that you do not defraud. You don't use this system to be able to defraud your creditors. So those are some of the things, of the alternatives to bankruptcy that you can be able to put across. So I think I've talked about the no asset procedure. I've talked about the installment order, and I think I have also talked about. Did I talk about the liquidation? Abigail, you can help me, or Vicky? I don't know how many I've talked about.
I'm listening keenly because immediately after you are through, I will take through all the steps to clarify and to tell all this I'm taking from my notes.
Yes, kindly. You can pick up on the other. I think the other two which I'm not. It's not very clear in my mind, but yes.
Good. So when I was doing the rationale of having these oral sessions, ilikuwa pia where people watakuwa na difficulty to answer, it is important we revisit that question in its all element of it to avoid a situation mtu ataingia orals alafu juu ulishika only a certain element, wakati unaulizwa another question inakuwa challenge. So I decided to break it down as follows. Whenever you are told to give the two types of liquidations, okay, involving a company, we have members voluntary liquidation, we have creditors voluntary liquidation, and we have liquidation by the court. Now, do you clearly understand what each entails? Members voluntary liquidation applies where the company is solvent and the shareholders decide to wind it up voluntarily. It is suitable where the company can pay its debts and the shareholders want to close it formally, or the company has achieved its purpose and the company can pay its debts. So there is no serious creditor disputes at this point. The liquidator will just pay the debt, they will distribute the surplus assets and conclude the company's affairs. That is what members voluntary liquidation talks about as a type of liquidation involving a company. The second step or type is creditors voluntary liquidation. This applies where the company is or is likely to be insolvent, but the process is commenced voluntarily. This is provided under Section 4(6) of the Insolvency Act, that the company must convene a creditors meeting, and the creditors and the company may nominate an authorized insolvency practitioner to act as the liquidator, and then the creditors have a major role because the company's assets are insufficient to pay everyone in full. That is the basic interpretation of what happens inside creditors voluntary liquidation. Then you go to liquidation by the court. This is compulsory liquidation through a court order, and it is provided under Section 425 of the Insolvency Act. And a liquidation application may be made among others where we have a creditor, a provisional liquidator. So these are the people who are entitled to apply for this kind of an order from court. You can also be asked in oral, kindly give us the list of the people who can apply for a compulsory liquidation through a court order. The company or its director, a creditor, a contributor or shareholder, a provisional liquidator, and an administrator, or a liquidator where the company is already in voluntary liquidation. Okay, you could have started with voluntary liquidation, but now you have instructed the liquidator to go to court to seek a court's liquidation order. Those are the people who are entitled. And then the High Court will supervise the court liquidation of Kenyan companies. You will be subjected to supervision of the court. Now, whenever you are asked this question, now sasa sikia another angle you can be asked on your orals. Kindly give us the main alternatives to liquidation. Tulianza na nini? Give us the various types of liquidation. Tukasema ni ngapi? 3. Members voluntary, creditors voluntary, alafu kuna liquidation by the court. But now sasa sikia, give the main alternatives to liquidation. Number 1, administration. It is a rescue procedure where an administrator takes control of the company with the aim of rescuing the company as a going concern and achieving a better result for creditors than immediate liquidation or realizing property to make distributions to secured or preferential creditors. Administration is useful where the business is still viable but needs protection from creditor action while a restructuring or sale arrangement is underway. So that is an alternative to liquidation. Another alternative to liquidation, we have company voluntary arrangement. A company voluntary arrangement is a formal compromise between the company and its creditors. Under Section 625 of the Insolvency Act, the directors may propose a voluntary arrangement under which the company enters into the following: 1. A composition in satisfaction of its debts or a scheme for arranging its financial affairs. And only an authorized insolvency practitioner may supervise this kind of arrangements. And once approved, the arrangement can bind the company and the creditors. Under Section 630, an approved proposal takes effect as a voluntary arrangement and binds relevant creditors and the company. So be keen. Another, nataka kuiframe venye tu inafremiwa. Another main alternative to liquidation, apart from administration, we have a situation where the company can do a voluntary arrangement with the creditors. So they are undertaking to arrange its financial affairs, protecting itself from creditors' applications. That is 2. 3. Scheme of arrangement or compromise. A company may use a scheme of arrangement under the Companies Act, especially where the restructuring affects creditors, shareholders, classes of creditors, or classes of members. Under Section 923 of the Companies Act, the court may order meetings of creditors or members to consider a proposed compromise or arrangement. If the required creditors or members approve the arrangement, the court may sanction it. And once sanctioned and lodged with the registrar, it becomes binding, and the court has powers to facilitate reconstruction or amalgamation, including transfer of property and liabilities and dissolution without liquidation of a transferor company. So that is the other way, another alternative, main alternative to liquidation. Scheme of arrangement or compromise, and we have seen even the court in its own capacity can direct a company to enter into such kind of arrangements or compromise. Then another alternative is where we have informal creditor workout. A creditor may negotiate directly with the creditors without commencing formal insolvency proceedings. It is that direct. Then we have receivership or secured creditor enforcement. This is where a company has granted security and a secured creditor may enforce its security by appointing a receiver or exercising other enforceable rights. Okay? Remember, this is not a full company rescue mechanism. It is usually a creditor driven and focused on recovering the secured debt. So this is another alternative to liquidation where the creditor may amua directly, let me appoint a receiver to secure our secured securities from that company. Then we have sale of business or assets as a going concern. Instead of liquidating the company may decide to sell part of its business. It can sell non-core assets, it can sell subsidiaries, it can sell its land, plant and machinery, and even receivables. This can raise funds now to pay creditors and keep the company alive. Then a merger and reconstruction or amalgamation is also another alternative to liquidation. A company may avoid liquidation through a merger or restructuring. Then you have voluntary dissolution. If the company is dormant, has no debts, and is not involved in insolvency proceedings, it may consider striking off or dissolution rather than liquidation. But it is not suitable where it has not paid creditors. Remember, you can make an application directly to the registrar to make your company be struck off from the register of companies in Kenya. That is also an alternative to liquidation. So key takeaways. The panel imekuuliza, kindly give us the types of liquidation. The types in regards to a company, members, creditors, liquidation by court. That's it. Kindly give us the main methods that act as alternatives to liquidation. Yani you are telling the panel, si kila siku lazima tuingie under liquidation arrangements. We can try to settle these things outside this framework, and we can try administration. We can try company voluntary arrangement with the creditors. We can also try a scheme of arrangement or compromise. We can also try informal creditor workout. We can also try receivership. We can also try sale of business or assets as a going concern. We can also try merger or amalgamation and reconstructions. We can also try doing an application to be struck off from the register of companies because we don't have any debt and we don't want to be a potential for debts in future. Hapo ndo kin. Na nimenote this confusion where Mr. Martin, you asked a question, but Abigail na Arnold wakashindwa exactly what do you want them to respond to. Is it a type or is it an alternative to liquidation process itself? Up to that point, I believe it was very, very clear. Now, what are the options for a natural person? What are the options for a natural person? Under Kenyan law, a natural person facing bankruptcy, facing insolvency, begin. A natural person facing insolvency may consider 1. Bankruptcy, may consider individual voluntary arrangement, may consider summary installment order, may consider no asset procedure, may consider informal debt restructuring or settlement, may consider debt consolidation, and may also consider asset sale or negotiated creditor workout. Bankruptcy. Bankruptcy, sasa ndio naanza kudefine. Bankruptcy is the formal insolvency process for individuals. Under Section 15 of the Insolvency Act, a bankruptcy application may be made by the following people. It may be made by a creditor, by the debtor himself, or the supervisor of a debtor who is bound by a voluntary arrangement. So 3 people, creditor, debtor, or a supervisor of a debtor. Then, a bankruptcy order may be made if the debtor is sufficiently connected to Kenya. For example, if he is domiciled in Kenya, is personally present in Kenya when the application is made, or has ordinarily resided, had a place of residence or place of business in Kenya. What is the effect of a bankruptcy order? Under Section 48 of the Insolvency Act, once bankruptcy commences, proceedings to recover the bankrupt's debts are generally stayed, and the bankrupt's property vests in the official receiver. So, as a key takeaway, bankruptcy is therefore serious because the debtor loses control over assets and the process becomes public. So those are the effects of being a bankrupt. Now, individual voluntary arrangement. An individual voluntary arrangement is a formal compromise between an individual debtor and creditors. It is provided under Section 303 of the Insolvency Act because it says that a voluntary arrangement involves a proposal by a natural person to the creditors for the following reasons. Whether you want a composition in satisfaction of debts or a scheme of arrangement of the debtor's financial affairs. Under Section 304, a debtor may apply to court for an interim order if the debtor intends to make such a proposal. The proposal must provide for a supervisor, and only an authorized insolvency practitioner may act as a supervisor. We are discussing individual voluntary arrangement. So hapa umesema you want to do a proposal to the creditors, but you can also obtain what we call interim orders from the court. And for you to be granted this interim order, the proposal must provide for a supervisor, and you are told by section 3 or 4 of the Insolvency Act that this supervisor is only an authorized insolvency practitioner that can act as a supervisor. Why are you using this method? You are using it because it is useful where the debtor has income or assets and can offer creditors something better than bankruptcy. That's it. And if this method is approved, the proposal will take effect as a voluntary arrangement under section 312 and bind relevant creditors. And then section 315 tells us that the supervisor will implement and supervise the arrangement. Then, what is a summary installment order as another way? A summary installment order is another statutory alternative to bankruptcy. Under section 323 of the Insolvency Act, it allows the debtor's debts to be paid in installments or in another approved manner. And a debtor may apply for a summary installment order. And the debtor's application must include, among other details, the debtor's full name and address, property details, creditors' names and amount, whether any debts are secured, what are your earnings, what is your employment detail, what is the proposed installment and the proposed supervisor, unless the debtor says a supervisor is unnecessary. Section 326 tells us that the official receiver may make a summary installment order where the following is proved: that the debtor's unsecured provable debts do not exceed the amount prescribed by the insolvency regulations, and where the debtor is unable to immediately pay those debts. These are the grounds that the official receiver will consider before making a summary installment order. You cannot pay that debt immediately, and the debtor's unsecured provable debts do not exceed the amount prescribed by the insolvency regulations. And the effect will be that the debtor must pay installments as required. And if the debtor will default, the official receiver will cancel the order. What is the other step? We have no asset procedure. The no asset procedure is for an individual debtor who has no realizable asset and no means to repay the debts. So you don't have assets. And under section 343 of the Insolvency Act, it tells us that it is a procedure for dealing with a debtor who has no realizable assets. A debtor who meets the criteria may apply to the official receiver for entry into the no asset procedure. What are the conditions that you must satisfy? You must satisfy that you have no realizable asset, that the debtor has not been previously admitted to the no asset procedure, the debtor has not previously been adjudged bankrupt, the debtor's total debts are not less than 100,000 and not more than 4 million, and the debtor has no means to repay any amount towards those debts. Another rider where you are not sure of the amounts to insert, you can say the total debts as prescribed under section 345 of the Insolvency Act, in particular to the no asset procedure. What will be the effect? The effect is that creditors generally cannot enforce their debts that became subject to the no asset procedure. However, there are some debts that are excluded pursuant to section 351. The debts that are excluded are amounts payable under a court order under the Marriage Act, amounts payable under the Children Act, and debts relating to loans to secure the education of a dependent child or stepchild. So be keen. A question can come. Kindly advise this client to choose the best method of alternative to a natural alternative to bankruptcy of a natural person. So, and if you read the fact sheet laid before you, you are realizing that this person has no assets, has no realizable assets, and no means to repay the debts. So if you don't have the means and no realizable asset, that is the key identifier, and you have not been previously admitted to the no asset procedure, and you have never been previously adjudged bankrupt, and your total debts are within the prescribed range, and you don't have any means to repay any amount towards those debts, and then the examiner is telling you that you have been awarded maybe some awards after a certain divorce procedure has been conducted successfully, or you have approached the children court and you have been awarded maintenance amount every month, okay, and then there is also a debt that you have taken to secure education of a dependent, maybe for further educational advancements. Those are exceptions. You cannot go after them. So we are telling the Act, Section 351 is telling the creditors, hey, look, once a debtor has been subjected to the no asset procedure, you cannot enforce debts that became subject to this procedure. And these debts are excluded totally, those debts that I have laid before you. And under Section 359 talks about a discharge. A debtor is automatically discharged from the no asset procedure after 12 months, unless the period is deferred in accordance with the Act. Okay, so you can be told that 12 months have lapsed after this person was incorporated into the no asset procedure by the official receiver, and it is on the 13th month, and now the creditor wants to go after this person. So remember, you have been automatically discharged from the no asset procedure after 12 months unless the period is deferred. Under Section 360, upon discharge, debts that became unenforceable on entry into the no asset procedure are generally cancelled. But debts involving fraud or fraudulent breach of trust are not cancelled. So this creditor hawezi sasa kukujia to enforce a debt that became unenforceable on entry into the no asset procedure because they have been cancelled. Another way is we have informal debt restructuring. This is a simple one. Before bankruptcy or formal insolvency process, an individual may negotiate directly with the creditors. So this is informal debt restructuring directly with the creditors. Then you can have debt consolidation. A debtor may consolidate several debts into one facility. And then we have sale of assets by agreement. A debtor may negotiate with creditors to sell assets voluntarily and apply proceeds to debts. So up to that point, I am confident that when you are asked to give a short answer on main alternatives to liquidation, to bankruptcy, you'll say individual voluntary arrangement, summary installment order, no asset procedure, informal creditor restructuring, debt consolidation, voluntary sale of assets. Yes, Mr. Martin, that marks the end of that discussion.
I want you to take me through the the exceptions for no asset procedure kindly. I know you've talked about education to the dependent children. You've talked about award for maintenance after divorce proceedings. What was the other one?
Amounts payable under the Children Act.
How is it different from maintenance after divorce?
Okay, that was an example because what is directly excluded is amounts payable under a court order under the Marriage Act. Under the Marriage Act. So if it is on maintenance ama separation cost ama the cost of a divorce umepewa by the court, hivyo ndo unaweza jaribu kuinterpret, but basically any court order under the marriage act yenye inakupea amount.
My question,
Yes.
my follow-up question on that. Supposing I have a divorce proceedings, and in my divorce proceedings, probably the court awards a maintenance that is above 100,000. Where does that leave that debt? What will happen?
Okay. And you have received sorry, nilikuwa na multitask. So to break it down, Mr. Martin, break it down venye nitaielewa this question clearly.
I'm asking,
What are you saying?
this is that you have brought about. You're saying that when you're going to the no asset procedure, number one, you have to be able to. We are saying we have to be able to demonstrate the ingredients. One is that you're unable to pay those debts. You're totally unable to pay those debts, right? Isn't it?
Yes, that is well captured.
My question: you have exception of a court order that has gone ahead and awarded a maintenance after the divorce that has resulted to a decree of above 100,000, assuming. So then, how do you treat that? Because now you're saying you want to put me at a no answer procedure. At the same time, this you're still I'm still being subjected to maintenance that is above the threshold. So how does it work? Or do you go back again to court to you need to be able to vary this order, given that I'm actually a pauper, or what happened?
I'll answer through a scenario that I have. An example is where assume a court orders a spouse to pay 500,000 to the other spouse as part of a matrimonial relief. If the paying spouse enters the no asset procedure, that obligation is not treated like an ordinary commercial debt. It remains enforceable because it arises under a court order connected to the Marriage Act. Okay? So, in effect, this means that, let me read out the effect, is that you can still go after this amount. It remains enforceable. Unaona? Yani sijui, okay, let me try to rephrase my situation. Nimeenda court, the court ikasema I be paid 500,000. But sasa my wife akaenda akasema ameingia into the no asset procedure. Remember we said once umewekwa kwa the no asset procedure, all debts that were to be enforced, but we are not able to enforce those debts because you are under this scheme will be cancelled. Immediately umetoka under the no asset procedure, maybe after the lapse of 12 months or after other stringencies. Now, the wife anasema hivyo because anajaribu kudefeat the court's order in paying this 500,000 as matrimonial relief. This is where the act inatuambia, hey, look, that is excluded, you will still have to pay. It remains enforceable because it arises under a court order connected to the Marriage Act. That is how I could have tried, maybe, Mr. Martin, to answer your question through that scenario. Maybe I stand guided, kama bring out clearly how the exceptions are to be applicable.
No, I totally am getting the fact that when you get that relief, then you need to be able to, it's not going to be subjected to your, because I'm just trying to imagine, look at it from this point. When, for you to be entered to no asset procedure, number one, it means that, remember, you have, first of all, to have been unable and you don't have prospects of paying those debts. So my question, maybe what I need to ask is, or maybe what I need to understand is, so are we going to be able to put this relief that has been given in Abe until your finances get back to order, or what happens? Is that what you're saying?
Good, good. I've now understood your question. What I can say, Mr. Martin, at the point where you are still under this no asset, I will try as much as possible to execute still against you, because I've been told by the Act, hey, look, this is not an exception. Okay, this is an exception to the rule. Remember, for the other dates, different, because they will be cancelled immediately nimetoka from this no asset procedure. It has protected me. But sasa, the question that you are raising is very critical. Do we have to hold in abeyance this person because mimi niko na the right to execute, but one of the conditions of being subjected to the no asset procedure was that you were unable to pay. That's a very good question. Now sasa hiyo inamaanisha utakuwa na judgment on paper in the normal sense. Yeah, mimi naweza iweka tu hivyo, Mr. Martin. That is a very tricky situation to be in my position, unless any other member can try. Ama Mr. Martin, pay, you can clarify on my thoughts.
I would think the same way, because if you look at it critically, there are two things. Remember, one of the ingredients is that you're being told you're going to the no asset procedure, and you need to go with clean hands. That you're not trying to commit fraud. So I'm just trying to look at it from that perspective without sounding like Kashem rather. That here you have a marriage, you have that review that has been a decree that has been given by court that you need to be able to go and do a maintenance, but at the same time you have gone to seek the no asset procedure, and then at the same time, then you're saying you have this relief that you can be able to pay. The same case with education, for example. Yeah, supposing the education is going to require that you pay X amount of money, the tuition that probably sums up to probably amount over and above that are going to be able to go above the threshold. So I don't know. And that's why I'm seeing like probably there is either a lacuna there, or is it that because you can have a situation for real where you have gone pursued a divorce, and the kids are in school, and the tuition that they're going to be, the total tuition probably goes beyond the threshold, the 100K and thereabout, so that you find you have those debts that you have accumulated. So what happens? Are you when you get this no asset, are you going to be able to give those? Are they going to be cancelled, or what happens? Or are we now then going to say that it's going to stay in abeyance, that you still have to go back when you get back on your feet?
That is a tricky one, Mr. Martin. That is a tricky one. So up to that point, kwanza, we can agree, we can come to a conclusion, kwanza, Mr. Martin. We have correctly captured whichever angle the question can come. We can even explain, not only mentioning them, we can go to the extent of explaining, giving the tests for each to be applicable, giving the exceptions to each, and the panel will appreciate that we have duly mastered this unit on insolvency on a natural person and a company. Mr. Martin, I also remember your key takeaway assignment on section 19, I've not yet forgotten, where we had a heated debate on the interpretation of section 19 as read with section 33, and in partial part of the section 15 thereabouts, and the interpretation part of the prescribed minimum level of a bankrupt. So that is still under consideration.
Finally, when you're doing
unless
you can actually
yes
include this those exceptions for non-liquid, non-asset procedure, no asset procedure rather. Thank you.
Thank you, Mr. Martin. That is well captured. Maybe perhaps you can explain to the panel on why we are saying that was a key takeaway so that they understand the point of divergence. You say your part and you clearly bring out my part so that they can also understand, so that wasikuwa on a float whenever it comes to an examination situation, because we saw it is a very potential area to be asked when it comes to such a question.
Okay, if I remember the discussion we had that day, we were saying that if you go to Regulation 3, it says the threshold is 250,000 for any bankruptcy bankruptcy proceedings to commence. Then when you go to Regulation 19 and led together with Section 33, Section 19 talks about the minimum value, that the prescribed minimum value, which is 500,000, and also on B it talked about the small bankruptcy level, which is about 100,000. Yeah, so we are saying the total assets that for you to be declared, I mean, for you to be able to even think about bankruptcy proceedings of a natural person, their total asset should not pass the 500K mark. All right. Then the total unsecured debts should not be below 100,000. So basically, that is it. So you have to ensure, like for example, and remember here you're talking about unsecured. At the line, unsecured, not secured, because secured it means that secured you have that land that you have secured, so it's an asset that already can be liquidated to realize the debt, to realize the amount that is owed. So here it's just talking about the unsecured debt. So basically that was the point of argument. So that if, for example, if you have assets that are even above 500,000, then it means you can actually be put at the bankruptcy proceedings. Thank you.
Thank you so much, Mr. Martin, for that. So all members have correctly captured the same. So that is the point of research that we undertook to do, to take, and now we add on the exceptions under the non-asset procedure. So we continue with the oral sessions, and this is where I laid out the powers to the members, where you can put anyone on spot, where you have a question. Mr. Cheduk, the floor is yours. You can ask or be asked a question. And Mr. Arnold, also, you can take the floor so that we hear you.
Okay, on my issue, okay, just a simple, not really a question but a clarification. Yenye najua hiyo lazima ikuje kwenye nikikutana na watu wa nini wa trial advocacy. You know about hizi vitu za nini, the opening statement. Okay, opening statement. Maybe I direct to the owner of hapa Abigail.
Abigail,
just procedure of opening statement.
Abigail drop. You can forward it to Chedwick. Chedwick hajaongea.
Yeah. Chedi. Opening statement. Just the procedure.
Okay, so in opening statement, there are two elements that are involved. So first we have case theory and case theme. So basically, case theme is what the case is about, like the context of the case, while case theory is basically I'll talk about case theory is now the genesis of your case, like how you frame your case, marinate the law it generated, how to the case at hand. So it's basically like case theme, like you see for the Mweni case, it was a divorce proceeding. So you can say that case theme is about a divorce. While case theory now is now basically how the case came to be about. So in opening statement, you have to marry the two. So for example, if I'm talking about the Faith Mweni case, I would do an opening statement in a way that, for example, we see the Elisha Ongwea case of the Rigathi Gachagua case, the trial of the trial of Jesus, the trial of who the way he framed his case to bring it to the context and prove that all of those were just done because of formalities. So in the case of Faith Muini, you talk about uh, my client is has been subjected to um, 13 years of marriage in existence, and it will be so ironical that at this point, when now my client is being subjected to such kind of uh, trial for the sake of being deprived of what rightfully belongs to her as a wife who has stayed with the defendant for almost 13 years. So basically, the opening statement is what it encompasses the case theory and the case theme in general. So you just have to marry it and make it logical, number one. It has to have a sequence, number two, and it should be consistent with the fact at hand, not just like basically creating a narrative out of it, but you have to actually bring out what your case is about, because this will help the court to understand on what ground you're basing your argument. So I'll talk about it in that context.
Okay, thank you. Go.
Yes, yes, yes,
Yeah,
Arnold.
good.
Good evening.
Good evening.
I think my attempt to be my understanding is that when you do the opening statement in any case, you need to be able to bring the court to the attention of what the case is all about. And for you to be able to do that, you then are able to approach it from the perspective, as Chadwick said, you need to be able to tell what the theme being this one sentence, one phrase that contextualizes that summarizes the entire case. Is it about justice in trial? Is it about and for in what context? Then the theory actually tells the story. What is the story behind this theme that you have that you're trying to be able to contextualize, so that you're able to tell the story of your client. You're able uh, to demonstrate through the story how you're going to be able to demonstrate through to tell the story, how you're going to demonstrate through the witnesses, through some of the documents that you're going to be able to bring out to court, so that you can be able to tell the story. It's actually the story, you give the facts, that you just give a highlight of the facts that you're going to be able to depend on, so that you can be able to uh, to bring out the theme. You know, what is this that you want the court to be able to see, so that if, for example, it's a murder trial, then the theme will be if you are defense counsel, or if you are depending on the side of if you're a defense counsel, then you need to be able to bring out the innocence of your clients. So the theme is to prove that indeed this person was not the person who committed this crime. And to be able to prove this, we are going to depend on ABCD, and then you're able to give the genesis of your story as the theory that you're going to be able to focus your story around.